Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Ryan Suit, a Virginia construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Ryan Suit.
Thank you, Jesse. Thank you, everyone, for attending. Good afternoon. My name is Ryan Suit. I'm an attorney at Pender Coward in Virginia Beach, Virginia, and let's get right into it. So just some housekeeping up front. If you have any questions throughout the broadcast, or if I go too fast or skip over something, or you want me to review something more at the end, just shoot a question or comment to the right side of your screen in the chat box. We'll handle those all at the end of the presentation. If you do make a comment or question, please don't include any names or company names. Let's keep everything hypothetical, but feel free to ask away at any time. So on today's agenda, we'll first talk about some general contract tips before moving into securing your lien rights and securing your bond rights. We'll talk about a few other rules and exceptions to lien and bond law. We'll go over a few lien law traps to avoid, and then discuss the right way to exchange a release for a check. And then Jesse will discuss some of SunRay's resources. So your contract, and one change to make. So the first general contract tips that I have are review your contract. Make sure the terms are up to date. I see a lot of contractors using contract templates for 20, 30 years or more, but I usually recommend taking a look every year or so just to stay on top of it and make sure the terms of your contracts reflect the work that you're actually performing. Another important point is to properly identify the parties and get their signatures. A lot of different companies are either incorporated or they're LLCs or they're under fictitious names and DBAs, doing business as. But you need to have the right entity on the contract up front, because if you end up in court, you want to make sure that the correct entity that you want to sue is actually who signed your contract. In every contract, you also want to specify the scope of work. That way, everyone is on the same page from the very get-go, and that can save you a lot of headaches down the road if you do run into issues. And every contract needs to include payment terms. So whether that's net 30, net 60, whatever have you, whatever you're comfortable with, but also include interest and late fees provision. Typically, what I usually see in my practice is contracts with 2% interest per month for late payments and 25% per year, and that's a pretty big number. By statute, if you don't have an interest provision in your contract, the court can only grant you 6%. So by putting in an interest provision in your contract, you're making sure that you get more money from those who don't pay. The one big change that you want to make to your contract, if you don't have it already, add an attorney's fees provision. Virginia is an American rule state, which means that by default, each party pays for its own legal fees. So if there is no attorney's fees provision in your contract, you cannot collect attorney's fees if you go into litigation. So make sure that's in there, because disputes are inevitable. Eventually, you're going to run into a problem client, or you're going to have a dispute with someone else. So make sure you're preparing ahead of time with an attorney's fees provision so you can save on costs. Another note is to choose your venue. If you don't have a venue and jurisdiction provision in your contract, put one in there. That way you are basically choosing which court that you file suit in or which court you are sued in yourself. So make sure you get the home field advantage and choose where you want any lawsuits to be filed. Now, one caveat with that is in Virginia, a mechanics lien has to be filed and enforced in the city or county in which the project occurs. You can't contract that away, but for general contract matters, add in that venue and jurisdiction provision. So now we'll get into securing your lien rights. Here, just up front is by statute who can file a mechanics lien. It's all persons performing labor or furnishing materials worth $150 or more on a project. That's also any person providing labor or furnishing material to condo units or the limited common elements of a condo unit or HOA or POA. It's also any person who is providing labor or materials for site development. So that's, if you're doing grading for a development or installing traffic signals or installing utilities, any work that's done for an entire development rather than a single lot or parcel can file a mechanics lien. So when you're securing your lien rights, you need to know the timeline. So this is a bit of a mouthful, but a mechanics lien can be filed within 90 days from the last day of the month in which the last work was performed. So what that means is if you did work earlier this month in April, you have from April 30th a 90-day timeline to file a mechanics lien. So just for reference, that would be July of this year. And we do have a cheat sheet here at our office, so if you ever want to have something quick to look at to know what the mechanics lien deadlines are, feel free to reach out to me after the webinar. Another key part of the timeline in Virginia is the 150-day rule. So what this rule means is that liens only look back for 150 days prior to the last day the work was performed. So if you have a 6-month project, roughly 180 days, but you don't file a mechanics lien until after your work is done, in that lien, you can only put in the work that was performed in the last 150 days. And you can't put in anything that was performed in that first 30. A way around this is that you're entitled to file multiple mechanics liens. And if you have a long ongoing project, that might be the best route. Once you file a mechanics lien, you have 6 months to enforce it, or 60 days after the completion or termination of a project. The statute says whichever time shall last occur. So if you file a lien and 6 months passes, but the project is still ongoing, once it's completed, you do have another 60 days to file a mechanics lien. Here's just a list of the information that is needed to perfect the lien and to include in the memorandum of lien. Pretty straightforward. Most of this information should be in the contract, or you should have it. And in addition to this information, there are a couple other requirements. For one, general contractors have to file with the court when they record the mechanics lien proof that they mailed a copy of the lien to the owner. So this is important because when you're looking at a 90-day timeline, you want to make sure you have time to draft the lien, send it to the owner, and then also have a copy of that mailing ready to be filed with the court. So you don't want to wait to the last minute just because there's a lot of small boxes to check. For subcontractors, they also have to give notice in writing of the amount and character of their claim. That has to be sent to the general contractor or to the owner or his agent. So now we'll move into securing your bond rights. In Virginia, there are no bonds required by statute for private projects. Now, that doesn't mean that bonds are never required, as an owner of a project can still require bonds from a prime contractor. But generally, if you're working on a private project, a mechanics lien is your best remedy. For public projects, it's a little bit different. There are no mechanics lien rights at all in Virginia for public projects. There are two kinds of bonds that are used on these public projects: performance bonds and payment bonds. Performance bonds are mostly for the owner's benefit. And so if you're a contractor, you're looking at the payment bonds. And big key here is to always get a copy of the bond if you're working on one of these projects. Any project that's in any public project in excess of $500,000 is required to have these bonds. Any project that is related to transportation in excess of $350,000 is also required to have these bonds. And that is those are the thresholds for requirement of performance and payment bonds, but a locality can also require bonds for contracts in lesser amounts than those on the slide. Also of note, bid bonds may be required, and those can be valued up to 5% of the bid amount, and that's just so the locality can ensure that any contractor making a bid, if they're awarded the contract, will actually follow through and perform the work. So Virginia has the Little Miller Act, and this is basically the rules on how to sue on a bond. It's very similar to the Federal Miller Act, where there are two types of claimants that are covered. There are first-tier claimants, and that's anyone who has a contract with a prime contractor, and then second-tier claimants, which is anyone who has a contract with a subcontractor. If you are below that in the chain, and a third-tier claimant or below, you may not be covered. The Virginia Supreme Court actually has not ruled on this issue of whether the Little Miller Act covers third-tier claimants, and there's some conflicting case law in the lower courts, so it's a bit of a gray area. And so if you are a third-tier claimant or below on a public project, you want to err on the side that you might not be covered and prepare accordingly. Under the Act, prime contractors can also require subs to furnish payment bonds. And the most important part of this slide is the limitations under the Little Miller Act. If you are going to file and sue on the bond as a claimant, you have to wait 90 days from the last date of your performance to sue on the bond. So you have to wait about 3 months from when you finished your work. But you also have to sue on the bond within 1 year from the last date of performance. So essentially, you have about a 9-month window on which you can actually sue on the bond. And additionally, if you're a second-tier claimant, you have to file a notice within 90 days of your performance to the contractor. And that we recommend using certified mail to serve that notice, just because you want to have proof that you actually sent it in order to enforce your bond rights. So let's get into some of the more specific rules and exceptions. So for liens, like I said, you have to file a mechanics lien within 90 days of the last day of the last month of work. But that is not always the case. If the project is completed or for some reason it's terminated for abandonment, foreclosure, what have you, the 90-day clock starts ticking at that point. So if you were to finish work at the beginning of the month, but you're the last worker on the project, your 90 days starts then rather than at the end of the month. So a little bit of variability there just to be aware of. Additionally, there's a special rule for residential construction. If a building permit sets forth the name and address of a mechanics lien agent, then written notice has to be given to that agent within 30 days of performance beginning. So you have a month, more or less, from when you start work to submit that notice. And if the notice is not provided within 30 days, then the lien that, if you have to file a lien down the road, that lien may be limited to the amount due to you after the notice was given. So don't forfeit that first month of work and make sure you get that notice in on residential construction projects. For bonds, these are just a couple tidbits pursuant to the statutes. Damages for unreasonable delays cannot be waived on public projects. So if there are some kind of delays, you are most likely going to be on the hook for them. Additionally, any waiver of right to sue on a bond is void unless in writing. So there can't be any oral agreements to not sue on a bond. So just a couple things to be aware of. And some other things to be aware of, most importantly, traps to avoid in lien law. Every contractor who wants to file a mechanics lien has to have a valid license from the Board of Contractors and also have the proper class of license. So if you're a Class B contractor, but you're doing Class A contractor work, you are not entitled to file a mechanics lien. And so you want to make sure that your licensure is correct, and you also want to make sure that the work you're doing is proper for your class of license. Personal liability for liens, we'll get into that on the next slide. A big thing to remember is that not all work counts towards that 90-day deadline. Again, this is why the scope of work being included up front in a contract is so important, because if you are doing the scope of work and then on April 30th that ends, and then on May 1st you go in to do some cleanup, some punch list items, what have you, you may not have until the end of May now for that 90-day deadline or the 90-day clock to start. So there's some case law there that really, if you're performing the scope of the work, you have that month and the 90 days thereafter. But if not, your clock is just a little bit shorter. This may be obvious, this last one, but you never want to include work not performed in your memorandum of lien. If you have anything in there extra that maybe was in your contract but you didn't do, if that's in there, you can forfeit the entire lien. Court is not going to carve out just a small part of it. It has to be 100% correct in order to be valid and enforceable. So personal liability for liens, just something to be aware of for general contractors and subcontractors. The GCs can be held personally liable for liens. If a subcontractor gives preliminary notice of a claim with the probable amount of the value of their work while they're performing it, and then after they complete their work, send a second notice within 30 days of the end of the project with the correct value of the work that they performed, then the general contractor can be held personally liable to that subcontractor. So that's either something to be aware of if you're a GC or a weapon in your arsenal if you're a subcontractor. Now we'll get into the right way to exchange a release for a check. At the end of the day, when you get paid, that should resolve your claim. That's the goal. And so we always recommend having funds wired to you so that they are immediately available. That way, you don't have to worry about checks bouncing and things dragging on. Make sure you get a wire before you release any claims and get the money in your pocket first. Additionally, you always want to review your release and make sure you are releasing what you want to release. Specificity is key here. Additionally, any release, you want to make sure it's mutual. So if you're releasing a claim against another party, you want to make sure that they are also releasing you of anything so that they can't come back and drag things on further. So with that, looks like we're done in about 16, 17 minutes. And I'll turn things over to Jesse.
Thank you so much, Ryan. That was really great. You touched on a lot of different topics and gave us a lot of information, so I appreciate that. All right, so for the questions that came through, we do have a few, and some of them I think you did touch on, but maybe a little further explanation is needed or just some clarification.
Sure.
So the first question that came through, it says, if my work was longer than 150 days that the lien covers, how can I protect my company? Should I have more than one lien filed?
Yeah, so if it's a long ongoing project, you can file liens during the project. If you know it's going to go longer for 150 days and you want to ensure you're going to get paid, then filing a first lien to cover that first 150 days, you can do that. And then once the project is completed, file a second lien.
Perfect. Thank you so much for that clarification on that. And then there's another question. It says, can my attorney's fees and filing fees be included in the lien amount?
No, those would not be included in the lien amount when you're first filing the lien. But when you are enforcing the lien and filing suit on that, that's when you can bring in the costs and fees for litigation. So that's not work that's actually performed, and so that can't go into the mechanics lien.
Okay, wonderful. And then it says, do I have to have a written contract to have lien rights?
I would say always have a written contract.
Always best.
Yeah, I would err on the side of that. I don't think that I haven't run into just an oral contract that involves a mechanics lien. And so best practice would definitely be to have a written contract in any work that you take on.
Wonderful. And then you briefly touched about this topic, and they were asking, is there a standard form for a lien waiver that Virginia uses, or is there a certain language that you would recommend having in there?
So I would have to take a look at the statute for a waiver of lien, because I touched on some of the basics, but there are a number of more minute details when you get into waiver. And so that's really a question of fact on the contract and the exact situation you have. So that's hard to say from a high level, but anytime you're waiving your rights, you want to be really careful.
Yep, pay attention to what the language has on there. Make sure it's releasing only what you're wanting to release it for, and not an open-ended waiver. That is all the questions that have come through right now. If you guys do have another question or somebody thinks of a question that wasn't addressed, please feel free to reach out to me and I'll be sure to answer any questions for you. Ryan, can you go ahead and go to the next slide for us, please?
Yep, sure thing.
All right, so who is ready to win a gift? We are testing your knowledge. If you're able to answer these questions correctly in the chat, we'll go ahead and send you guys over a little prize, a little gift from us. Here are the questions. It says, when is the deadline to file a memorandum for mechanics lien in Virginia? And then the other question is, how long is Virginia's look back period? He did touch on this, and one of our questions was actually talking about this. So pay attention. If you know those answers, go ahead and chime in for us, and we'll send you guys over a little gift from us. All right, can you go to the next slide for me, please? All right, so here are some of our SunRay resources to help you guys stay organized, know your deadlines, and secure your lien rights. Scan this QR code for us to access these resources. You'll have the deadline calculator, project information sheets. We also have state lien law rules. So if you are doing work in a neighboring state, each state has their own lien laws of what types of documents, what deadlines are required. So make sure you're checking that out so you guys can protect yourselves and ensure that you guys do have lien rights on your projects. So go ahead and scan that and check it out. You can always reach out to us if you need further information. Can you go to the next slide for me, please?
Yep.
Thank you. All right, we have our new service available at SunRay. It's SR Receivables. We'll help with your collections for you guys. We're here to help get you guys paid. So if you are needing help with your collections, go ahead and give us a call, send us an email, and we will give you some information on that. Next slide, please. All right, our next webinar with Ryan about Virginia's lien law is going to be don't sign a release unless it says this one thing. That's going to be Wednesday, November 6th at 12 p.m. Eastern. So go ahead and register for free at sunraynotice.com/education. We'd love to be able to see you there. Go ahead and go to the next slide if you don't mind.
Mm-hmm.
All right, if you don't mind, give us a little quick review on Google. We appreciate any feedback you can give us. It helps better our webinars, get some of the information that you're looking for to you, and it helps to get this information to more contractors and suppliers like you. So go ahead and scan that and give us that review if you don't mind. And then the next slide, if you can. Perfect.
Yep.
All right, and with that, that is all we have for you guys today. Thank you so much again to everybody who did attend. We hope to see you at our next webinar. Thank you again, Ryan. You are incredible, and I hope you all have a wonderful and sunny day. Thanks, everyone.